afternoon, everybody. It's Rob Seaver, Executive Director. I have said that 3 times before we practice, and I knew I was going to mess up. I'm with Leads Council. Thank you again for joining us on this week's webinar. I'm super excited about this. I know you hear me say that every time, but this is one where I have actually done this one in some iteration with one of the guys on this panel today, many times from the stage, and I love it. I'm very passionate about it. I think you're going to become passionate about it. You're going to learn a lot, and I'm super excited. Before we get started with that, though, I want to do a little housekeeping. Inside your control panel, there should be a chat and a question section. What I would ask of you is that if you have questions, our panelists have agreed to answer questions along the way. They also have agreed if we can't get to them in the course of this, they will try to answer them afterwards. We're also recording this, so if for some reason you have to drop off or you want to watch this again, I will have this posted in the next 24 to 48 hours, maybe 96. It depends on how busy I get. Anyway, without further ado, I'm super excited. This is building wheelchair ramps for your website. That's pretty exciting. I don't know what it really means. We're going to find out what it means. I'm going to start off with one of our panelists. It is Jason McKee. I'm sorry. He's the Chief Marketing Officer with Accessibility Shield. I've only introduced him 8 times before. And so, Jason, listen, you and I have had this conversation a million times. We've talked about why this is important. This goes far beyond the business model that either of us have. Help me understand, 1, what you do for Accessibility Shield, and 2, help me understand why it was important for you and why it should be important for the people in the audience.
Hi, Rob. Thank you for having me. Thank you, everyone, for joining. Excuse me. I'm very excited to be here and talk about my favorite topic, which is accessibility. I'll give you a little background of how I got into this. I was in digital marketing for many years, advertising and things like that. And I had a small marketing firm that I ran, and my partner ran a software company. We joined together on a couple projects. We got to a meeting one day with a prospective client, and the gentleman was blind, and he was using a screen reader when we walked into the room. He had a laptop with no monitor on it. It was a kind of a jarring experience to see someone use a screen reader. That's basically how the visually impaired access the internet. This gentleman, in midlife, he was a successful businessman for most of his life. He developed an illness. Doctor said, "You're fine." He woke up 9 days later from a coma, and he couldn't see. And his father came into the room and said, "You got to figure something out, man. The vision's not coming back. What are you going to do?" So he explained from that perspective how he learned how to use the internet. And he was very outspoken. He was from Brooklyn, and he was like, "Listen, this damn internet doesn't work. It's supposed to work. There's even a law in the books about making this stuff accessible. And since I lost my sight, none of this stuff works." And he just gave me an earful. And the whole meeting really was geared around understanding his perspective. My partner and I, 7 days later, formed Accessibility Shield. We were so shocked that we didn't know, we never considered in our careers. And I've been around a few years. I'm 46 years old. I've had a long career. I never thought of this. It's never come up in any of the meetings as we developed websites, designed marketing campaigns, everything we've done. It's never come up. No one's in any of those rooms I've been in has ever mentioned it. So I don't hold anybody who's on the call and is like, "I didn't know anything about this." Don't feel bad. That's why we're talking about this right now. And when you realize what we mean when we say accessibility, when you realize who we're talking about, this is, if you look at the number of disabled people who need help accessing technology today, it's 1.3 billion people worldwide. 1.3 billion. If you add in their immediate family members, that's 53% of people on Earth that this affects immediately, directly. So this is a big thing, and why it hasn't been part of technology is an interesting story that we can talk about a little bit if there's time. In fact, the internet itself was inspired by the disabled to communicate better with each other. It was actually a gentleman who wanted to woo a woman he fell in love with who was deaf. So he developed the technology to communicate with her, to get her to say, "Yes, I'll marry you," and it worked. His name is Vince Cerf. He's the chief scientist at Google. This is real. Look it up. It's real, folks. And Vince Cerf is a huge advocate and proponent of this, obviously. He wants everything to be accessible. When we get into what that means, we'll talk about that a little bit later, but there's a lot of exciting things about accessibility. It's not a, "You're going to get sued, you're in trouble, you should have done this, should have done that" type of conversation. It's more of, "Hey, let's talk about a new perspective. Let's talk about what this means for other people. And let's talk about making it more inclusive for everyone and equitable for everyone." I mean, in today's society, every single day, we're seeing things happen in our world about inclusion, diversity, and equity that should be discussed, and this is just part of that conversation. So I'm happy to be here.
Awesome. Well, Jason, I know from experience on the stage, you are not short of these stories that we're going to hear more of today. So I'm super excited about that. I know you probably told that one, but I just don't remember it. So it was all new to me. So I want to move on to our next guest, and I'm pretty excited about this one because she comes from a state that I lived in. She's in the great state of Tennessee. In fact, the town, if I don't butcher it, is Ottawa, I think. Erica Kramer, your partner with Hudson Cook. Help me understand, one, what you do at Hudson Cook. What does Hudson Cook do? And then why are you on this call today? Help me understand that.
Sure, yeah, happy to. And I'll say I already learned something too, because I always thought that Al Gore invented the internet, but now I know that not to be true, despite. Well, yeah, thanks so much for having me here today. Hudson Cook, in general, we are a law firm. We like to consider ourselves what we call a boutique national law firm because financial services is all that we do. And so in my practice specifically, I work with financial service companies in the regulatory compliance space. And so what that means is that I, on a day-to-day basis, help those types of companies comply with the alphabet soup of laws on the federal level that regulate that industry, as well as similar laws that each state has in place also. A big part of the work that I do focuses on a few different laws, so laws generally, but then also a lot of laws with respect to the military, like the Military Lending Act and the Service Member Civil Relief Act, and then of course what we're here to talk about today, which is the Americans with Disabilities Act. I really liked what Jason mentioned, which is that, and I think that's really important with respect to the priorities, because when we're talking about this issue, it's important to keep in mind that accessibility for disabled individuals is really a necessity. We should view it as a necessity and not as a luxury. I recently heard an accessibility advocate speaking about that, and that really drove home for me that we're not just looking at these laws and what do they say and what have courts said and all of that. And although that's an important part of this analysis, we need to stay focused on who we're trying to serve. For me, when I came to Hudson Cook in 2015, I had spent 10 years prior working for a legal aid agency doing very different work, family law work, landlord-tenant work, and some consumer work as well. And so when I shifted my practice, I also had a strong desire to continue doing something that felt like it was really still getting in the trenches and helping folks on both sides of the coin, both helping companies from regulatory compliance perspective, and in this case, helping them serve consumers, serve their customers, in a way that makes it accessible for everyone. So I'd say that's why this is such an important topic for me.
Well, I remember this was probably 6, maybe 10 months ago. I don't know exactly the date, maybe even a year ago. Things have been frozen in time for so long lately. I was really busy working on CCPA, the California Consumer Privacy Act, TCPA, the Telephone Consumer Protection Act, and just a wide variety of other compliance and regulatory issues that consume the council. And I inherited a lot of those, especially in the financial services, the CFP. Anyway, I got this call from a gentleman. His name was Jason McKee. Out of the blue, somebody referred him to me, and I was knee deep in something, and he started talking about this ADA thing, and I was just like, the only ADA I know, because I have an autistic daughter, is Americans with Disability Act, but how could this relate to anything related to anything interesting to the council? And as Jason started talking to me, the one thing that I did get from that one call is a ton of anxiety. In fact, I talked to Jason. If you remember, Jason, I was like, stop. I'm not at a point right now where I could take on another issue, right? And I remember I asked you, just hold off a second. And it took us a little bit to get that conversation going. But when I sat down and I listened to you, when I sat down and understood what you, one, were trying to do, but two, the risk that every single lead generator in our industry, every single member of the Leads Council has that probably is ignorant to, it was this. the WCAG. I'm saying it wrong, but help the people understand one about that conversation. And I do want to get a little bit into the actual council stuff here in a second, how it applies, but just help me recap that conversation and where we are as a threat level index in the industry to every single member we have.
Right, and let me just let me address that conversation that we
Did I
had,
get it
Rob, just to
wrong?
clarify.
Sorry if I did. Turning
I
53
made my
next week. I forget a lot of stuff.
You're correct. I made my pitch. I was introduced, a mutual friend introduced me to Joey Liner, DMS, who then said, you should talk to Rob, and that's how we got on the phone. And I gave you this long-winded pitch, and then here's what Rob did on the other end of the phone. I don't want to hear this, man.
I didn't.
It's like, this is not something I want to do. Another problem for my clients is not what I need right now. But unfortunately, it is a compliance issue that is on the books. Not only that, it's been around for a few years. ADA was written in 1990, so 30 years ago, the public accommodation was basically, if you're a business, you're not allowed to discriminate based on physical or mental disabilities. That's, it comes from Martin Luther King. It comes from the best place of humanity. It comes from equality and fairness. It comes from a great place. And the gentleman who helped write that law in 1990 is a partner of ours. His name's Jim Weissman. He's the CEO of a group called United Spinal. He got that law approved in DC in 20 months. And he was a young man at that time. He said, I didn't really know what we did, but now I'm like, oh my God, how do we do? He's like, I've been trying to repeat that type of success the rest of my career. Not only did they get it approved in 20 months, but they transformed the building codes and the physical infrastructure of one of the largest countries on earth in like a split second. It really transformed the world for the disabled. Now that the web has grown and become part of our lives, which we see with COVID right now, everybody isolated, having to work and communicate and shop online. A lot of the disabled people that I talk to were like, hey, how's it feel? You're isolated and you can't communicate and you can't. That's my life. I live with that every day. So how does it feel? Because that's what we're dealing with. And the only access we have to information and products and services is the web, and that's not accessible. There's a group that does a study of the 1 million largest websites in the world. Every year they update it. 98.1% are completely inaccessible today. So this law has been on the books. Creative lawyers started applying the ADA law to websites successfully, saying, hey, you're discriminating, so you have to accommodate these disabled. There hasn't been a lot of clarity in what that law is, and I'm going to let Erica handle everything on the legal side. But in my understanding, the Department of Justice says you're not allowed to discriminate and you should be accessible. But they're not really telling the companies exactly what to do. And the WCAG that you referred to, that's the Web Content Accessibility Guidelines. They were developed by Sir Tim Berners-Lee, the guy who invented the World Wide Web. The W3C, the group that he still chairs, it's a global nonprofit that develops standards for the web. They've had these standards the whole time. Tim Berners-Lee understood the need for intermediary devices to access this information. He knew we had to, it's like building codes. It's like electrician codes. You have to have some kind of standards, therefore others can use it in a different way. And he knew the screen reader aspect of this, speech to text, he knew early on. So he knew that if they defined these standards and developed them the right way, companies would be able to develop products that would let the disabled access this information. So that most commonly is the screen reader, which is a device that travels around the HTML code and reads out the information based on the structure of that code. If it's a label, it'll tell you what the label is. If it's a link, it'll tell you where the link is going to go. If it's an article, it'll tell you how big the article is and what it's about. It's the headline, the headers, all the basic HTML formatting that the average programmer knows. That's where this lies. So when people are inaccessible, it's just them not applying the right labels and things like that. That's as simple as we're talking about here. It doesn't have to be $1 million. Doesn't mean you need a rocket scientist to do it. You just need to understand what these standards are. So we call them WCAG, Web Content Accessibility Guidelines. Right now, version 2.1 is the latest. There's different conformance levels. There's A, AA, and AAA. AA is generally, if a company is sued, and again, I'll let Erica correct me if I'm wrong here, but if a company is sued, usually the settlement is, okay, you're going to make your website WCAG 2.1 AA compliant. That would be the standard for private businesses in America today. It sounds complicated, just like everything bureaucratic is, but it's not. It's basically allowing another device to access your code on your website to explain what it is to someone who's not using the keyboard, mouse, or screen gestures that the average user uses.
You know, Erica, as he's talking all that jibber jabber right now, because quite honestly, I started to say, oh, wait, I'm experiencing a little anxiety again, even after I've been through the audit. Help me bring it back to reality. You're in the courtroom with these things. You know what's going on right now as it relates to these plaintiff attorneys who are coming and bringing these lawsuits. They're picking up a phone book, which I know most people don't know what is today. But the thing is that they're just going through mom and pops, nail salons, hair salons. I mean, these risks aren't just associated with big corporate businesses, but yet as a big corporate business, you have a lot of risk and exposure. You in the courtroom, what is this like? What are you seeing? And really help me take what Jason just said and put it down into real terms that some of these people on the calls can actually understand.
Yeah, sure. Well, I mean, I think it is important to sort of take a look at the kind of legal underpinnings of this, current climate. And so for a number of years, as Jason alluded to, the Department of Justice had promulgated some proposed regulations that were going to actually put forth a standard as to how to measure accessibility, because there's sort of a two-part conundrum here. One is that the Americans with Disabilities Act does not specifically speak to web content accessibility. Reason for that? Well, like Jason pointed out, I mean, this was passed in 1990. You know, the internet did not occupy its current place in our everyday lives, pre-COVID, and now particularly in the midst of COVID. And so that's really significant. So we have these proposed regulations out there. They sat out there for a number of years. And then with the administration change, they were withdrawn. So even though folks kept thinking, what's going to happen, we're going to start to see some final regs and some real guidance, that did not ultimately occur, and they were withdrawn. So in the meantime, what is happening? Well, we're getting a lot of plaintiffs' filings, as you mentioned, and so the plaintiffs are going to court and saying, hey, I tried to use your website, I tried to use my screen reader, whatever the case may be, and I encountered these accessibility barriers, and so this is not permitted under the Americans with Disabilities Act. We really saw these case numbers absolutely skyrocket, and so that was significant, and it was significant enough for companies to go back to the DOJ and say, listen, you've got to give us some guidelines. You didn't tell us. Does the web content apply? Does the ADA apply to web content? Does it not? What do we do? How do we make our sites accessible? And we really need you to weigh in. And, continuing with the legal history, there also became an interesting split amongst the courts. And maybe this is the kind of thing that's only interesting to lawyers, but I'll say it anyway. So there are a number of courts who look to this issue and say, okay, the ADA only applies to public accommodations, Part 3 of the ADA, which is what we're kind of talking about here. It applies to public accommodations. And so is a website, is that a public accommodation? Well, so we have courts that say yes and courts that say no. Some courts in some districts say you have to have a nexus between a website and some type of products or services that are offered through a physical brick and mortar location. So that's kind of one set. And then the other set says, no, the ADA promised people more than just physical access. Technology evolves, things change over the years, and physical access isn't the only promise here. It's equal use of all types of public accommodation sort of services. So that term should be broad enough to actually encompass a website without respect to having a physical place where you could actually go. So that continued to exist out there. And so again, businesses went to the Department of Justice, legislatures on the federal level went to the Department of Justice, so we really need you to weigh in here, tell us something. So the Department of Justice, after some passage of time, did say something, but it wasn't much. Essentially, they issued a statement saying, the ADA does not specifically speak to web content accessibility. We know that. But that doesn't mean it doesn't apply. So yes, the ADA applies to the websites of public accommodations. And more than that, we're not going to tell you, because that was the other ask, is is how do we measure accessibility? How do we know that? And the DOJ said, we're not going to tell you. We're going to give you some flexibility. We're not going to mandate specific standards. And just because you don't comply with certain specific standards doesn't mean that you're not accessible. So I think on the face of it, the idea it was that that was supposed to be helpful, you know, that you have flexibility to figure this out. Ultimately, I don't think that's been the impact, because the plaintiff's activity continues in this space. It's sort of steadied out over the past year or two, but it's still significant. And we still don't have a lot of good answers. And so what that does, you know, drive us towards is looking at what's been done in the past. And as Jason pointed out, what's been done in the past is typically courts and regulators back in the day when regulators were kind of enforcing this issue. And they're turning towards the WCAG 2.1 and saying you need to get to this AA compliance here with these guidelines. So that's really what we're seeing. And I do think, you know, it's interesting to talk about. I know you mentioned the TCPA, mentioned the CCPA, and so when we talk about you know, about penalties or sort of what's on the line here, you know, there may not be the same risk of substantial monetary damages, although the risk is there. There are penalties that are imposed where, you know, for example, attorney fees are available if you file a suit, a private plaintiff suit alleging these types of claims, as well as orders to remediate the facility. So get the person, you know, the company to fix it and make it accessible. But there's some real significant reputational risk here too, that you should always be keeping in mind. That again, you know, if we're looking at accessibility as a necessity, not a luxury, you have a very wide community of folks that are deeply affected by this issue. As Jason pointed out, the numbers and the population. So there's some real significant risk all around. You know, in addition, once the, you know, if the administration changes later this year, then that will be another, you know, change that we may see too, is that this issue really may be picked up again, whether it's through regulations or whether it's just through enforcement activity, where the DOJ is going to come back in and start, you know, dealing with this issue. And I mean, lastly, I'll say, you know, I think on the state level too is something else to consider. So CCPA is a great example of a place where we've seen the WCAG standards essentially incorporated into the requirements, and certainly accessibility incorporated into the requirements and the regs there. And we may see states do that more and more to combat the sort of lack of federal regulation on this issue.
Yeah, I think I'm going to bounce into the, you know, some of that relative information as it relates to existing code. And, you know, you talked a little bit about, you know, private right of action. Like, I remember we were, Jason, I think we were in California maybe, and you were on the stage and you were talking about the impact that this has and potentially could have on your business. And I remember standing at the back of the room with Eric Troutman, who of TCPAworld.com fame. He would love for me to pitch that and say his name. So I'm doing it. He owes me $100 again. Anyway, I remember him looking at me and goes, "No teeth, no teeth." Remember, you know, you came off the stage and I was like, "No teeth, brother, no teeth." Like, help me understand. Like, yes, maybe, and you know, Erica, I think you could piggyback off of this as well. That private right of action seems to be, especially as a risk mitigation or risk versus, you know, reward, whatever, in the lead gen space, people look at, okay, TCPA, I could get, you know, blasted out of the water with any dollar amount. TSR, you know, with the FTC, I could get blasted with millions and millions of dollars. And so they're always at the top of the list of what is important to our businesses in this industry. But, you know, just because it doesn't say private right of action, or there's not an unlimited cap at the top, which is what usually trickles, you know, the attention of a lot of these decision makers in these companies, the risk is big. Address that, Jason, and subsequently, you know, Erica, if you could follow up on that, address that, but also address the fact that there are some big companies that have gone through some very expensive, you know, cases. I would believe you said maybe Winn-Dixie or something. There's some high profile cases as it relates to ADA. Help me understand what it means.
Yeah, and it's a good point. And there is a difference in the penalties here, and I'm going to let Erica speak to that. But I will say, we see like the Winn-Dixie case, for instance. This is, and I'm going to talk about this more from the human level interest, because yeah, there are companies who can say this might cost us $100,000 if we get bit. Put that in the risk column, and they don't give a shit. I know that is a thing. It's not a thing for me, and I don't have time for. If that's the way you're going to go, then go do it. But what we're talking about here is something a little bigger. Winn-Dixie case. Gentleman is blind. He uses the Winn-Dixie website to get his shopping list together, to go to the store. One of the first things I learned when I started getting into this and talking to disabled people is the visually impaired would say, try to close your eyes and go grocery shopping. Tell me what that's like for you. Imagine trying to navigate that type of environment without being able to see. It is absolutely impossible, right? We talk about wheelchair ramps kind of in jest in terms of websites and things like that, and those doors may open automatically and make it easy for you to walk in. But if you can't see in a grocery store, the number of products and the way that they're laid out, it is a nightmare. So this gentleman was trying to use technology to help it. It's not accessible. He just wanted to get the shopping list together, and then he was going to go in and ask someone for help. Can you help me get these items? Okay, that's his I'm going to eat to survive daily ritual. Okay, let's just start with that. Winn-Dixie refused to listen to his complaints. He filed a lawsuit. They refused to address it. Their arguments were things like, we just updated the website. We spent $3 million on the website. We can't afford this. This type of nonsense that the judge did not want to hear. Winn-Dixie was the first case that went all the way to trial and lost. And again, the arrogance from the general counsel of some of these companies, when you start getting into this and reading the court documents, your blood will be boiling. Domino's is another one. Domino's had a campaign a few years back where their food was so ridiculous that they had photos of people's terrible pizza. And the CEO did an ad campaign saying, we know this has happened. I take full responsibility. I'm sorry, we're going to fix it. They developed a pizza tracker app. They rebranded their website. They came up with all this, quality is going to be essential, whatever, blah, 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 blah. None of it was accessible. Domino's argument when they got sued, again, by a blind gentleman who wanted to use the pizza tracker app because it let him customize his pizza and get a discount. Their response was, why don't you just call? Why can't you have someone drive you in? You don't need this. It wasn't even, oh, geez, we didn't realize it. It was complete arrogance. Domino's fought this, tried to get all the way to the Supreme Court last year. Last autumn, they were backed by the groups are United States Chambers of Commerce, some kind of restaurant legal fund. It's like a pool of restaurant legal money that everybody was behind Domino's. Get this thing out of the way. This accessibility crap, make it go away. And Domino's is going to do that because it's expensive, it's unfair, it's unclear in what we're supposed to do. Our IT people can't figure out how to do it. This ridiculous argument. And the Supreme Court, and I forget the actual terminology, but they petitioned the Supreme Court, please review this, and vote and rule in favor of us. Supreme Court said this has already been ruled on. The lower courts already convicted you of this violation. It's not something we need to address. You're in violation of these regulations. So, and my point in getting off on this tangent is that I don't know how much money Domino's spent in that, but the number of times they went to court and the number of lawyers they have and the people behind them saying, here's some money to help with it. This is real money now. We're talking about real money, even in Washington, D.C. circles, we're talking about real money. So it is a risk. Now, on the other side of that coin, companies like mine, I get a phone call from an immigrant business owner in Philadelphia crying her eyes out because her nail salon got sued. And the demand letter said, I need $30,000, 20 for me, 10 for my client, or you're going to court. It's going to cost you 10 times that. I'm going to shut you down. She writes a check, calls me terrified, says, I don't even know what this is. Can you fix it? How much is it going to cost? This is an 8-page, $200 WordPress website. And this is the trolling that we're seeing from this, these lawyers who are actually doing these, what we call drive-by lawsuits. Again, the community that we are serving and trying to make things accessible hates that fact of things. They don't want that to be the notion of the average person sitting on their couch is saying, oh, there's disabled people putting everyone into court and costing them money. That's not the angle that we're trying to achieve here. We're trying to achieve accessibility, meaning everyone can use it. In order to get that conversation started, no one wants to hear it. So the big companies who talk about risk, this, like Eric Troutman said, he deals in a world where companies come out with an 8-figure a verdict against them. That's real money to them. That's a problem. So he makes sure that they're safe in those regulations. This is going to be less money for them, but it's even more important. I mean, it all comes from protecting the consumer. If the consumer is disabled, it doesn't mean that it's 1 in a million people. It's 20% of us. And any one of us in this room right now could wake up tomorrow without one of our senses. And all of a sudden now it's personal. And how many of us don't have someone in our family who isn't completely able-bodied? So it's, you know, and I'm going to let Erica talk to them. I'm sorry we're running on here, but the issue of money, it pisses me off on a number of levels. One, we can't have a conversation about what we're trying to talk about here because the CEO is not going to join in the call because it's less than $1 million penalty. You know, that type of thinking. You know, Erica touched on the brand reputation angle of this. If you don't understand what's going on in our society today, and you don't think that this new generation cares about how your brand acts as an individual in society and what they stand for and what they do and don't do, you're missing the whole. I hope you're ready to retire because your ship has sailed. Right now, people want to know what their companies, they want to choose to consume with people and companies that agree with things that they agree with. You have an opportunity as a company right now, someone on this call, to say, we're going to make accessibility a priority, and we're going to handle this because it's the right thing to do. I have seen in the last 6 months, companies make that decision, and I've seen the disabled community, which is a tight-knit community that spends money, come together and support individuals, and their bottom lines increase overnight because they've said, yeah, we're going to do this for the right reasons. And now all of a sudden, they have thousands of people behind them saying, yeah, every time they have a conversation, if you're going to go to a grocery store, go to this one because they know it, they get it, and they care. So it's not only the penalties, is my long-winded.
Well, Jason, as a moderator, I'm hoping that before the end of this call, I actually touch on something you're passionate about. Erica, Erica, I am used to Jason, and what's really great about this is whatever color thing is going on Jason's screen, it's making him like just change colors along the way. I'm loving it. It's just like angry, you know. It's actually I'm enjoying watching this. Erica, look. One of the things I heard or read, and I mean, look, the internet brings you a lot of good things and a lot of bad things, but there was a statistic that said like we could be looking at like an ADA website lawsuit in the year 2020, in the frequency of nearly 1 a minute. Like is this really ambulance chasing? Is this an area where the plaintiff attorneys had said, oh, there's gold over there and I'm going to run? What's the risk level? And then backing up to what Jason just said so passionately, you know, how can we roll this back into the reality of in the courtroom and why these people on the call and watching this down the road need to take this seriously?
Yeah, sure. I mean, and I think with respect to as far as like, you know, lawsuit volume, you know, again, I alluded to this a bit before. So from 2017 to 2018, there was 177% increase in the filings of inaccessible web content under the ADA. So that's a pretty significant growth rate. 2019, we didn't see the same level of increase, but the numbers stayed the same. There was a minute decrease, and I believe it was like 2 cases. So this is an issue that isn't going away. And so what I would say more than anything is that though there may not yet be hard and fast regulations, that is coming. And I think that, you know, I think Jason's point is a good one. You know, you're trying to get ahead of an issue that is not, you know, is not going away. And these cases read much like civil rights cases, as they should. An interesting example of that, I think, is the Winn-Dixie case that Jason was mentioning. You know, just in this last week, when the Bostic decision came out with respect to Title VII and the connotation of the terms homosexuality and transgender not being actually appearing in the statute. Those terms aren't there, and yet the Supreme Court, of course, issued an order saying that is part of what's intrinsic to Title VII. You cannot discriminate based on those terms because they're part of what we read into there when we say sex. And so in the Winn-Dixie case, which is still going on and still being litigated right now, they have right away filed pleadings saying that same application should be applied to these cases. So the ADA, does it say web content? No, it does not. Should we read it into it intrinsically? Absolutely, we should. And so these cases are good reads from that perspective. You know, to your point of, is this sort of, are we looking at ambulance chasers or are we looking at real plaintiffs? Well, I mean, unfortunately, I think as with many issues, it's some of both, right? I mean, plaintiffs' attorneys, I mentioned, and I don't think you can stress enough. I mean, obviously, you know, I'm a lawyer and I want to say we're all great, but that's not always the case, right? And so what the ADA has built into it as part of what you can get in addition to injunctive relief and an order to alter the facilities when you file a private lawsuit under the ADA is attorney's fees. So, I mean, there's definitely attorneys out there that are looking for these types of cases, you know, and because they know that they're going to generate fees. And so, you know, so I think that's sort of part of this. And so many of the, as in Jason's example of the small companies, you know, we've seen just rashes of demand letters coming from the same, you know, law firms and those kinds of things. And that frequently happens with almost any type of, you know, plaintiff litigation. You know, if there could be, you know, a whole bunch of claims to be built one on top of the other, that's going to happen. You know, if the, you know, as far as you asked about, you know, available additional penalties too. So, I mean, if complaints start being picked up again by the U.S. Attorney General, the penalties get, you know, more stringent. And so at that point, there are monetary damages and civil penalties that are available for $50,000 for the first violation or $100,000 for subsequent violation. Not TCPA level necessarily, but still not nothing either. And so that, I mean, is significant too if we're really just looking at the dollars and cents. But not to mention the dollars and cents involved in actually litigating a case. I mean, some of these cases have gone all the way up to, you know, the 11th Circuit, to the Supreme Court, those kinds of places. That's not cheap. You know, attorneys are not cheap. And so there's significant monetary risk all around this, even if you're not particularly persuaded by the necessity of providing this accessibility through your site.
Yeah, and I think you made a real definitive comment earlier about, you know, demand letters. You know, when you look at just the statistic of how many of these are making it to the court, there's a great deal that don't make it to the court and aren't included in the numbers of lawsuits that are actually happening out there, much like TCPA. Yep. I have no idea how many TCPA lawsuits are going on because often they're settled with that demand letter. And so I could imagine that that's the case with ADA.
Yeah, and I think that's true. And I mean, I also think that, even though I mentioned kind of the steadying of the rate of case filings, but I think that given the current COVID conditions, I think we're primed for a surge, both in demand letters as well as just, you know, in plaintiff filings.
So look, I think we've done a great job of kind of just painting the picture. Here at Leeds Counsel, I wear a t-shirt on occasion that says I scare because I care. When I'm in front of an audience, I wear that. It's Monster Ink font and everything. And it's truly kind of my mantra. I feel like there is a lot of uneducated people who want to know, but they just don't have access to what they need to know. And that's why it's important to bring this to the table. So I want to fast forward a little bit. Jason, as I was trying to, as an individual who is in charge of the entire organization's marketing initiatives, including our website, as I was continuing to build on that website, invest more time, invest more resource and money of our council members' money into our website, one of the things you and I agreed on, and we're still in the process of this, but we agreed that you would take the council's website as part of an example of what I need to understand and know. What I can tell you is that I worked with you, I worked with your team. I gave you access that you needed so that you could do a full scale audit on the back end. And then we had a call with one of your engineers. And I remember I got on that call and I really didn't have a lot of expectation. I had used a off-the-shelf product to become ADA compliant, thought I was there. And then the boom hit. The hammer dropped. I sat on that call, and in the entire process of that call, fight or flight, the human technique that we use every day kicked in to where I wanted to flight. I did not like what I was hearing. I was embarrassed because I'm the council, right? We've got to be compliant. It starts with us. And yet on just the homepage, just our homepage, we had over 800. And you said that's a low number. We had over 800 ADA possible failures. Man, dude, help the audience understand, one, the anxiety you saw from me when we were talking on that, and two, the fact that you told me it's actually relatively low, Rob. We've had websites where there are hundreds of thousands of failures on the ADA. Let's talk about that a little bit.
Yeah, and that's a good point. And when you think about it, and what Erica was just saying of, if this gets to a per violation type of penalty, I believe New York State has drafted or is drafting some kind of legislation at the state level that will charge per violation, or at least that's the goal of it. We work with a global hotel chain that we would all recognize. They had over 12,000 violations on their homepage. Start multiplying that by $50,000, and all of a sudden we'll have everyone's attention. The reason these numbers look like that, it's not, again, we're not trying to shame or bash or anything like that. This is, part of it is because of the nature of the code. So we have a website on WordPress that's a blog, and basically we can see a picture and we can read a paragraph of text. There's 10,000 lines of code behind that. That's how HTML works. It basically is the middleman between our eyes and our fingers and the actual information that's being portrayed. So it's not a white, it's not a text doc, right? There's code behind it. That code gets more complex, sometimes bloated. It doesn't need to be complex, but something we deal with a lot, especially in something like WordPress. I don't really know how to build websites, but it's out of the box. Please check this, make it ADA accessible. Thank you. Here's $50, all this stuff. Well, that's what the average person does. And that's why I was being honest. I said, you really shouldn't have any fear or anxiety about dealing with this, because this is part of the process.
I may have missed that actual recommendation, just so you know.
I mean,
I may have had to have an hour of therapy there for our call.
But it's very common to see small sites with a lot of violations. Now, some of those violations are, like the first time we were talking about it, Rob, was our scanning software, which is basically analyzing each line of HTML and comparing it against the standards that exist in the Web Content Accessibility Guidelines. That is really where the industry is right now on the surface, because you can get a free tool and you can push a button and it'll tell you how many violations there are. If I'm an attorney who wants to file a lot of demand letters, I can use that tool and I can just push a button, and all of a sudden everybody's website has tens of thousands of violations. I can file demand letters left and right. That is true because the web is not accessible, and the developers and designers who build everything are not paying attention to it. And the CMSs and the GoDaddies and the WordPresses and everyone else in the world who spits out hundreds of millions of pages, they don't care about it either. So that's where we're getting all these violations. It doesn't mean that it's $1 million to fix it, and it doesn't mean actually that they're all violations. There's subjectivity here, which is why the thing I have to talk about all day long is that this requires manual effort. This is subjective in nature, in the sense that this is a human being who needs to access it. I'll give you the simplest example that we use all the time. Alternative text is something that goes along with an image on a web page, and that is something that every developer knows about, but they don't really know why it's there. The first time I was at an event,
right? Alt text, you see it all the time when you're developing, right?
And in this community and in my industry, when people who have been around a while, when they present on stage, they deliver alt text. Hi, I'm Jason McKee. I'm 5'8". I'm wearing a blue t-shirt and jeans and boots right now. I'm 15 pounds overweight. And then I wait for a pause and I say, okay, I'm 50 pounds overweight. But there's the alternative description of what's happening on the stage is second nature to them, because they're always around people who don't see and feel things the way they do. That's what the alt text does on an image on a website. Now, if it's a man sitting in a chair, that alternative text could say man on chair. If it's Abraham Lincoln, it's not man on chair. And there is no software right now that can automatically attach accurate descriptions to these images. And again, this is, in the WCAG standards, this is 1.1.1. This is the very first simplest thing that we talk about. It's why I'm starting with it. You can't have software do that. So when we look at your homepage and it says there's 800 violations, that means my people have to go in and look at it. Are these real violations or not? because the software can only say, it looks like there's an image here and it doesn't look like there's a description, or it looks like there's a description, but how am I supposed to know if it's the right one? So it's at the simplest way to explain this is maybe there's only 200 on your homepage because these are false flags, or these are things that after having been audited have been proven to not be violations. Either way, a human being who's trained at this has gone through them. That's really what we're talking about.
I want to pause there for a second, because I remember we were in Orlando talking either at dinner or something when we were talking to other companies in this space, leaders, top companies in this space, and alt text came up with the image, and there is a question that basically just came up that I forwarded to the two of you. And I remember something really hit me, because I can't remember who it was, but they were like, do you remember the Boston City Marathon bombings and some of the imagery that was being shared of people bloodied on the curbs, and you know, first responders, you know, helping some of these people that were in critical care? If you could imagine being blind and your reader sitting there coming across a picture that just is so powerful for the people with sight, looking at something where devastation, a memorable moment of devastation, was presented and captured in just a small snap. But yet, as a blind person, they're being served Boston City Marathon bombing, you know, victim. And that's it. That's the alt text. And as soon as I heard that, all of a sudden things started clicking for me that I have to, as a web designer, as somebody who does control some of those alt text moments for our readers, I have to do a better job. So even if there wasn't a financial risk, the heart in me, the human element in me, the ethical side of me says, I, as a web designer, I, as somebody that represents a brand, has to do better. I can't just stop with Boston City Marathon bombing, you know, whatever. So
it's, yeah, it gets even deeper than that. So let's talk about video really quick. There's something called audio description. Most people probably don't know what that is. In my industry, we call it AD. It's common language. That means that when I put a video online, it's not enough to push a button and have captions. That's a violation of these standards that we're going by if you just try to put captions. Never mind if they're accurate or not. If they're accurate, even, it's still not enough. The reason being, these standards have determined by talking with this community that it's not enough just to have dialogue. And there's a great example. I was on stage with a woman who was blind, and she started talking about this by saying, what's that movie with the guy has a sled in the end? It's famous. You know what I mean? It's famous black and white movies. I can't think of it right now. But anyway, it's a famous movie, and at the very end, this word that he's been saying, he's a billionaire. It's based on Ralph Hearst or whatever, Randolph Hearst. And at the end, he's been saying this word, and they find out it was a toy he had as a kid, right? That's what he's been talking about. This guy that had more money than anybody else in the world. The thing that he really missed at the end of his life was the toy that he got when he was 8 years old or whatever. The way that scene plays out, none of that is spoken. You're seeing it on the stage, and he whispers the word, and then they show the image. So her opening joke was, what the hell happens at the end of that movie? Because it's the most famous movie. Everyone talks about it as being the best movie in history. I'm blind. I don't know.
I hope at some point you'll remember that. You've remembered so many other stories. Hey, Erica, while he's trying to get his senior citizen moment back in check with us, help me understand. We're talking about some very technical things here. And by the way, we've got some questions from the audience that I want to get to. So guys, keep coming with them. I'm going to get to them, I promise you. In fact, we just had somebody say, can Leeds Council have a part 2 of this thing, because it's massive. It doesn't seem like an hour is going to do this justice. And so all I can tell you, Marianne, I promise you, we'll follow this up with something else. But Erica, look, we're talking about alt text. We're talking about user experience, the subjective nature of what could happen in an audit, what does happen when you're sitting out there, just the personal side of developing a website. As a marketer, it becomes part of my DNA. Let's erase all that, because it starts off with you in a courtroom at times. And what is it like? Do we get into alt text moments inside the courtroom? Is that real? Is that something that gets broken down? Citizen Kane.
Well, I mean, yeah, there you go, Citizen Kane.
Thank you, Rob. Or Bob, sorry.
Oh goodness. Well, yeah. So I mean, so that's interesting. So first, I'll say I'm not a litigator of these cases. I am on the regulatory compliance side, so I won't claim any litigation fame to my name. That's for sure. But you know, I will say that I don't think that. Well, a couple of things. So first of all, as Jason mentioned, a lot of these cases do not actually go all the way to the courtroom, and you mentioned that as well. We're seeing, you know, out-of-court settlements predominantly, and I would think that unless you were getting into a very, very deeply litigated case, the court is not going to get into the real nitty-gritty of what the problems are. I think you're going to see a higher level of discovery that sort of is a matching to sort of, you know, 50,000 foot views of issue and failure to comply with the ADA. Because I mean, again, we don't have a matching of standards and law at this time. So a court isn't saying, do you comply with WCAG 1.1.1? No, rather they're saying, is your website accessible? You know, whatever we think that means under the ADA. And if the answer is no, then, you know, we move on to the next phase, which is, does this company have to be, you know, compelled to make it accessible? And so I think that's kind of the way to look at it. But, you know, I don't think a court is going to get into the deep nitty gritty of that.
But so then it brings it back to the passion side and the what we should be doing, because one of the things, you know, Jason, that you hit on, but I don't even know that we hit on it enough. The numbers are staggering of the people who need a more accessible experience. These are real customers of your product, your brand. And if we are shutting the door to a third, a half, whatever that number is, that's a real revenue slip for us. So, I mean, even if you didn't have the feels, if you didn't have the heart, we're talking about a real revenue driving opportunity that's missed. Is that an unfair or fair statement?
No, I agree 100%. Erica touched on it with the brand reputation element. It's becoming more and more important in our society today. Everything is transparent. Everybody learns everything about everybody. That's the world that we live in. So you can't get away from that. So if you really don't care, that's going to come out. And like I said before, if this is 20 to 25% of the individuals out there, that's 20-25% of consumers with money. That's if you want to just look at it from bottom line, then you're basically, you know, blocking out 20% of potential customers because you're refusing to address this. On the other side of that, once you do address it, and if you address it in the right way, you get people adopting you for life. They love it. I mean, I've seen this happen so many times, and I'm seeing this change just in the last 2 months. That the calls that I have used to be, oh my God, I was sued. What the hell is this? How cheap can you make it go away or whatever? Now I had to call somebody saying, you know, we got sued and we don't know what this is, but we'd like to learn more. We don't understand what this means. I don't understand what this means. And then you tell them like, okay, so how do we make it fair for everybody then? We don't even talk about money for the first call. It's about, well then, how, you know, I didn't know this was a thing. I didn't know I was blocking people from accessing this. And there's a legitimate concern there. Now, it's profit and loss world. We know that it's capitalism, but that doesn't mean we can't look at things and prioritize them based on what should be done and what shouldn't be done. And I'm seeing that more and more. I'm seeing a lot. You know, the silver lining for me in this fiasco that we're going through right now is that this is more a prominent conversation. This is something that people are talking about. School districts are talking about it. Universities are talking about it. Telemedicine's talking about it. A lot of real, you know, important industries are considering this as an option. That's in part due to this lockdown that we're going through. So if there is going to be a silver lining here, maybe it could be that we all come out of this with an understanding of different perspectives when it comes to interacting with digital.
I like moderating these things, and typically one of the talents that I have is the ability to manage the clock. And I just looked up because I have been knee-deep interested in what you guys are both saying here as many times as I've heard this, and we have about 5 more minutes left. Before we get out of this, I did not deliver everything, audience, that we want to deliver, and so I promise you a part 2 of this. There are a couple of questions. One, does WCAG apply to email? Quick answer, yes, no.
Yes, it applies to all HTML. HTML is based on email, and it absolutely applies.
Whoa, that was a good answer. Is there a best practices for alt text? Can you help with that, Jason? First of all, you're helping me with it. So yes, can you?
Yeah, just remember the example of, if it's a man on a chair, if it's Abraham Lincoln, that and what you were saying, the image is coming in from a bombing or a terrorist attack. What is the reaction for someone who can't see that screen? And I have blind people that I talk with all the time who love sports, were baseball players previously, and now they can't see, and they're like, I wish sports broadcasting would just catch on and give me a better feel for what is happening on that. Because if you watch baseball, you'll start to pay attention to what's happening in the audio. There's huge sections of nothing because it's a nice slow pace and they're just watching things happen. You hear the ball come in. These are the types of things that it's all alternative text. It's describing, it's the audio description we talked about. It's describing what's happening for people. We all should be more aware of that. And I love the fact that people get up on stage and give their own alternative description about who they are and how big the room is and where they are. And all that stuff shows that we are speaking to everybody here.
Erica, with a few minutes left, how can you help some of these companies? Where do you fit into this whole ecosystem, and how can they get a hold of you?
Sure. Yeah. So I mean, the reason that many folks come to us is first of all, when you're going to engage in this process of taking a look at your website and identifying barriers that need to be remediated, it can be beneficial, and many companies like to engage that third-party vendor to do those audits through a lawyer. And the benefit that gives you is that gives you some protection of attorney-client privilege. So whatever the results are of your audit, what steps you decide, how you're going to fix now, how you're going to fix later, those kinds of things, those become protected under attorney-client privilege. And that's pretty motivational for a lot of folks, given the fact that, again, we're seeing tons of plaintiff activity in this space, both on a demand letter and a complaint filing perspective. Sort of once you deal with the front end of actually going through the audit process, fixing the issues, prioritizing, and I think, maybe that's something we delve into in part two even more is, where do you kind of start with figuring out what to fix and some tips and tricks for that. But, so once you go through that process, an equal important part is shoring that up with policies and procedures so that you're not going back to A over and over again with respect to these accessibility issues. So you're coupling that with internal policies dealing with how often are we going to check this stuff, who's going to be in charge of checking it, how are we going to do it, going forward, who has the responsibility every time we change something on our web content, we have new content, we build a new app, all of those things, and keeping the compliance moving forward as your company moves forward after the initial dealing with the issue.
They can get a hold of you on LinkedIn?
Yep, LinkedIn is great. So that's probably the best way, or I'll give you my email address too, which is eKramer with the K, EKRAMER @hudco.com.
10 minutes for any attorney question. Okay, so I love having attorneys on here because, quite honestly, that's what people want to show up and listen to. So thank you, Erica, for that. Jason, I'll probably finish with you because there are a couple of questions that I want to say. Somebody asked, how can we is there a service? How can we have blind people tell us what's wrong? I know you're working on something like that. Secondly, how can they get a hold of you, and your website and your services also help take people through that transition of here's where we are, here's where we need to be, and how can we get a hold of you?
Yep, accessibilityshield.com is a site. There's a way to reach out to us through there, and there's a lot of helpful information. In terms of, what was the first part of that question? I'm sorry.
Whatever you want.
Yeah, so the disabled experience. Sorry. Citizen Kane was the movie. Rosebud was the name of the sled. Just so everyone.
Okay. No. Do you have a service where blind people can actually come in and explain their customer or their user experience?
Yeah, I'm glad you asked that because my company just formed a relationship with the state of Pennsylvania where we train disabled individuals to become user testers. That program is partially government funded. They help us pay the salary of these individuals while they're in training, and then we keep them as a valued resource to be able to provide an audit from the disabled user perspective to our clients. Nobody else is doing this. It's brand new. The position is brand new. We've already had calls from 2 other states that want to jump on. When you're disabled, the employment options are very limited, regardless of your background. So this is something that we see as a boon for the underemployed community of disabled people, but we also see it as a valuable resource and insight to all business owners. What was this like? So forget about WCAG this and 1.3. All that nonsense, forget about that. What's the experience like for someone who's disabled? How do they access my site and what issues do they have? That's what you're going to get from our program is a first person analysis of this report of the disabled user going to your website. These are the issues I encountered. This is how I fixed it. This is how frustrated I was, whatever it is. Or it's going to say, this is great. I could find this. I could get on that calendar. I could download this form, whatever it is. You're going to get real feedback from a disabled user's perspective who's been trained in the art of auditing, which is an art. It's not necessarily a science at that stage. It's UX type stuff, but it's a perspective you won't get from anywhere else. We're very proud of it, and we want it to be part of all companies in accessibility to provide that perspective from the disabled community.
How do they get a hold of you, Jason?
Accessibilityshield.com is the best way. Just go to the website and there's ways to reach out to us there.
Everybody, look, I've just had acknowledgement from both of the presenters that they're up for a 2.0 where we can dive deeper into this stuff. So look forward to that communication. Jason, I just volunteered you. I made it up that you actually said yes, but Erica did. Anyway, I'd like to talk a second about the council. We have a membership drive right now where we've dropped our silver membership down from $2,000 a year to $500 a year or $42 a month. That's a no-brainer. You get access not only to this, but some of the content that we're sharing just with our members. We have a diversity subcommittee or task force that's about to launch. I need people who are out there that want to get involved to contact me. It's rob@leadscouncil.org. I'm super excited about that, and we'll have more about that in the coming weeks. Guys, Erica, Jason, thank you very much. This is not only something that from a litigation and a risk side of it is important. This is something where people really need to do the right thing. And I hope that people get that out of this. I certainly did. I certainly appreciate your time. Thank you very much again, and we'll talk soon.
Thank you, Rob.
Thank you.